Good morning, or good afternoon, or good evening. Thank you for joining us today from around the world for this online book launch and panel discussion, which is also being recorded. A warm welcome from Nuremberg here on behalf of the International Nuremberg Principals Academy. My name is Viviane Dittrich and I'm Deputy Director of the International Nuremberg Principals Academy. My virtual background here today is Courtroom 600, the very courtroom where the Nuremberg trials took place from 1945 to 1946. Today I am joined by 5 distinguished colleagues and panelists, and I warmly would like to welcome Yuma Totani, who is Professor of Modern Japanese History at the University of Hawaii. Gary Simpson is Professor of International Law at the London School of Economics and Political Science. Kerstin von Lingen is Professor of Contemporary History at the University of Vienna. Philipp Osten is Professor of International Criminal Law at Keio University, Tokyo. And Jolana Makraiová is Senior Officer for Interdisciplinary Research at the International Nuremberg Principals Academy. In the next 90 minutes, we will present first the new book and then engage in a panel discussion discussing contemporary perspectives on law and history and the appreciation of the Tokyo Tribunal in Japan and internationally. We will speak about accountability and also about the ongoing significance of the Nuremberg and the Tokyo Tribunals. The panelists look forward to answering some of your questions in the course of the discussion, and we invite you to use the Q&A tool, which has been enabled on the bottom of your screens. Please keep in mind that due to the large number of participants and the limited time, not all questions may be answered. If you are tweeting, you may wish to use the hashtag Tokyo Tribunal. Now, it is my great pleasure to announce that our edited volume with the title The Tokyo Tribunal, Perspectives on Law, History and Memory was published this week. The book, the 3rd volume in the Nuremberg Academy Series, presents a contemporary rereading of the Tokyo Tribunal, which was officially named the International Military Tribunal for the Far East. The book offers a broad and rich spectrum of views by leading scholars on the historical, the legal, the social and the cultural significance of the trial that took place more than 70 years ago. The book is now available as an open access publication. At the outset, I would like to use this opportunity to acknowledge the contributions and the support of so many who have made this book possible. We are also grateful to the publisher and to the TOAP team. And of course, I'd like to recognize also the Nuremberg Academy team. My special thanks goes to my co-editors and all the contributors, many of whom are leading experts on the Tokyo Tribunal. I know that the authors are also here with us today. For those who are joining us now from near and far, I warmly welcome you, and especially our colleagues from Japan. Now I'd like to invite my co-editors for 5 minutes each to join me in presenting the book, first of all. First, let me give the virtual floor to my colleague Jolana Makraiová, who will give us a behind the scenes into how the book came into being, the inspiration for the book, the international conference organized by the Nuremberg Academy 2 years ago. Over to you, Jolana.
Thank you very much, Viviane, and hello and warm welcome to everyone. I would like to first start by joining Viviane in providing a brief but definitely not small thank yous to the co-editors, and especially thank you to Kerstin and Philipp. It has been an amazing almost 3 years of journey, and we are very grateful for all the work and dedication to the Nuremberg Academy Series. Secondly, to all contributors, as Viviane mentioned, many of you are following with us today, but heartwarmingly thank you on all our behalf. And lastly, to the Nuremberg Academy team, and especially preparing the Zoom webinar and all the magic hidden behind this. Now turning to the book and providing a brief background to the book itself. In 2017, the Nuremberg Academy was contemplating an idea of having its 2nd spring event marking the 70th anniversary of the Tokyo Tribunal and trial. So as we all do, we did embark onto a journey of research, which was not an easy task as we were aiming to achieve at least main 3 points. First was to create an event that is going to adequately mark the anniversary. Second was to bring something new and something unique into the discussion. And third was to advance the topic of ICL. We as a team here came up with an idea, which is quite brilliant in my view, and that was to test the possibility for the event, which was the following. As many of you will know, one branch of the Nuremberg Academy's core mandate is focusing on interdisciplinary and applied research. And we source from this premise, transferring the idea into creating a conference where on the one side, we have the main subject line focusing on a legal structure of the conference based on the Tokyo Tribunal and our legal understanding of it. This was the subject where we felt quite comfortable. On the other side, we aim to identify other issues that are or could be interlinked with the subjects that we chose and identified from varied angles and viewpoints. As a result, we created a varied panel in terms of expertise and also possibly reading of the judgment. With this in mind, the intention of the conference was to address the relevance of the judgment, crimes within the charter addressed in a judgment through the lens of history, law, and social science. We also looked at the similarities between the Nuremberg trial and the Tokyo and analyzed procedural obstacles faced by the judgment and the trial itself. Last but not least, we looked at the post-judgment development where the topics of perception and memory came in. All in all, we have gathered more than 30 experts leading the discussions in Nuremberg. We managed to hold an event that was most extensive event worldwide in 2018 related to historical trial, receiving considerable international resonance and media presence. And last but not least, we have gained the trust, the willingness and time of our experts to contribute to the fascinating book, which thanks to open access, you can all read now. I would like to briefly still touch upon the structure of the book and provide a basis for the discussions forward. The present book showcases current research by 18 international experts, including many leading scholars on the topic Tokyo Trial and Tokyo Tribunal. It offers multiple readings of the trial and combines different disciplinary perspectives in all parts with a view to an interdisciplinary dialogue. The book is divided into 3 parts following a logical sequence from the foundation and facets of the historic trial through the dynamics and dimensions of the trial, leading towards the perceptions and potential impact of the trial. I will not delve into each chapter briefly, given our time limitation, but I would like to once again stress the vast expertise of the contribution, and we will put the names of all contributors in our chat for referencing. Thank you very much.
Thanks, Jolana. And indeed, anniversaries and commemorative settings provide opportune moments to stimulate further critical reflection, foster ongoing dialogue, and deepen understanding. I'd like to now invite Professor Kerstin von Lingen, who is joining us from Vienna today, to give us a brief introduction to the Tokyo Tribunal from a historic perspective, mention the historic importance today and the book's contribution to scholarship and history. Over to you, Kerstin.
Thank you very much. So maybe starting with the facts, the Tokyo Tribunal was held from May 46 until November 48 under its official heading, International Military Tribunal for the Far East. So it was the sister trial to Nuremberg. In total, the tribunal consisted of 11 judges and national prosecution teams, a mixed Japanese-US defense team, and it indicted 28 defendants, amongst them former prime ministers, cabinet ministers, military leaders, and diplomats, and displayed an impressive list of 55 charges. The judgment was not unanimous. Besides a majority judgment, there were 2 concurring opinions and 3 dissenting opinions. And this is also the reason why it was perceived a bit of a failure. Different than to Nuremberg, the proceedings of the Tokyo Tribunal have not been published until nearly 50 years after the event. And this is also a reason why research started a bit later. So the idea of holding an international tribunal in Tokyo goes back to the Potsdam Declaration of the Western Allies, which proclaimed on July 26 in 1945, with respect to Japan in Article 10, that, I quote, "stern justice shall be meted out to all war criminals, including those who have visited cruelties upon our prisoners," end of quote. So after the US had dropped atomic bombs on Hiroshima and Nagasaki, Japan formally surrendered on September 2, 1945. So thereby also the Potsdam Declaration was accepted. The US then became the driving force behind planning the tribunal, and in February 1946, General Douglas MacArthur appointed the 9 judges who had been signing the instrument of surrender. So the limitation to the surrender signatories then later prompted some criticism in the Far Eastern Commission, where also India as well as the Philippines held a seat, and in view of their wartime surrendered, they successfully claimed also a seat on the bench. So from a historical perspective, when contextualizing the Tokyo trial, it is vital to reassess the national strategies behind the performances in court. What does the legal strategy adopted in court tell us about national perceptions of the Pacific War, and which hopes were connected to a successful performance in this international court? What was the understanding of a successful outcome of the trial, and how did that differ between the teams? And last, what happened to Tokyo's legal actors once they left the trial? What was the impact on their career, their mental horizons, and their politics? And can their biographies highlight broader social tensions and transformations? I would like to briefly highlight some points. So from the outset, the tribunal suffered from several flaws. It had many jurisdictional challenges ranging from victor's justice to challenges to the crimes, non-indictment of the emperor, the dismissal of bacteriological warfare charges, the question of sexual slavery, or the more representative than comprehensive selection of defendants. The defense suffered from a lack of time to prepare, language difficulties, inferior translation facilities, and logistical issues, as the shortage of desks, paper, typewriters, and money. Judges varied greatly in how they were affected by their different legal backgrounds, accommodation issues, postal delivery, the absence of their family visits for years, the poor quality of translation, as well as questions of procedure. In particular, the absence from duty at their home courts. The language barrier on the bench, notably access to English, hampered smooth communication between the judges, as at least 2 judges, Zarianov and Bernard, so the Russian and the French judge, did not speak English. The most serious challenges came, however, from Webb's trial conduct and the rejection of documents of evidence presented by the defense in court, is my opinion. However, the view that Tokyo was a failure, especially because of its second best legal personnel, is a critique that needs to be rejected. We see a lot of very devoted and expert men and some women who tried to make the utmost of their assignment to the novelty of an international court. It is also true that the charter for the tribunal itself was contested among the judges and formed the basis of concern and criticism on the bench. When addressing the human element of the trial, it is important to focus not only on the judges, but also on the chief prosecutors, on the defense counsel, and even to take a look systematically as translators and other staff, which remain a lacuna. A special case in point at Tokyo is the employment of female attorneys in the prosecution and as legal aides in the defense team. Scholarship has not yet comprehensively addressed the gender dimension of Tokyo, and it is still open to research to what degree the employment of female colleagues was a side effect of the shortage of personnel at Tokyo or a purposeful experiment. The fact remains that Tokyo was a pioneer in this regard, and thus more modern than, for example, the tribunal at Nuremberg, where women were in large part employed as stenotypists or secretaries only. So to sum up, while some judges underlined their national independence by voicing dissenting judgments, others were anxious to keep the bench as united as possible, so as to reinforce the legacy of Nuremberg. When assessing, for example, the British team and its partners from the Commonwealth, we see additionally something like an argumentation of professional honor, voicing standards of British justice as the basis for the trial, and upholding duties despite deep personal frustration and the wish to withdraw from Tokyo's lengthy proceedings. Thank you.
Excellent. Thank you very much, Kerstin. Now I'd like to invite Professor Philipp Osten, who is joining us from Tokyo today, to provide a brief introduction to the Tokyo Tribunal, highlighting the legal dimension and the legal scholarly view.
Thank you, Viviane, and good evening from Tokyo. As we have already heard, the year 2018 marked the 70th anniversary of the delivery of the judgment of the Tokyo Tribunal. And the book we present here today is maybe not the only publication based on or related to this anniversary, but perhaps its approach to this topic is one of the most diverse and international ones, considering the interdisciplinary approach and the wide range of different topics and different aspects covered by the chapters written by authors from all over the world, including eminent scholars from Japan, where the trial was conducted, and from where I have the pleasure to participate in this webinar today. From a legal point of view, the Tokyo and the Nuremberg tribunals, individually but also combined, may at least from a present-day perspective be regarded as groundbreaking measures which were foundational for modern international criminal law. Both serve as precedents in this regard, and they have often been quoted in judgments of the ad hoc tribunals, for example. And even though both trials have not been and still are not being treated on equal footing in international legal scholarship, it is interesting to note that, at least in recent years, their influence seems to be increasing. And influence in terms of precedential influence and precedential value. The most important and, of course, ongoing contribution of the Tokyo Tribunal is obviously the fact that its proceedings and the judgment, including the dissenting judgments, confirmed the law which was applied before that in Nuremberg, and further developed the concept of core crimes under international law, such as war crimes and crimes against humanity, and especially the concept of such crimes giving rise to individual criminal liability, including the liability of highest state and military leaders. However, as is widely known, and as Kerstin already pointed out, the outcome of the trial, that means the judgment, was not anonymous, with many dissenting opinions. And even though the majority judgment found all accused guilty, the proceedings and the outcome were far from what was expected by the Allied powers at the outset of the trial. No accused was, for example, convicted for crimes against humanity. This and many other issues pertaining, for example, to the principle of legality and the selectivity of the legal issues and the acts which fell under the jurisdiction of the tribunal. These matters gave rise to very strong criticism, controversy, and debates which continue even today, especially here in Japan. This said, it should perhaps be mentioned that the Tokyo Tribunal nonetheless has been more or less overlooked for many decades in the international legal scholarship and has only recently gained attention by legal scholars. Even today, it remains in the shadow of Nuremberg for the most part in legal scholarship. And our book hopes to contribute to changing this. It provides fresh views and sheds new light on a wide range of preeminent legal topics, ranging from very broad reconceptualizations to very narrow and detailed analysis. These topics include, for example, the treatment of sexual violence in the court's jurisprudence, new aspects pertaining to the notion of command or superior responsibility, or the slightly different definition and interpretation of the crimes as stipulated in the Tokyo Charter and the consequences of such particularities for the further development of international criminal law. So, furthermore, the book also, and this is a very important aspect, takes issue with specifically Japanese perceptions of the tribunal and the Japanese scholarly debate, both historically and legally. And in this regard, it is interesting to note that also Outside of Japan, the legal contribution of the Tokyo trial is receiving increasing reappraisal, as I just pointed out. Within Japan, only a very reluctant legal reassessment of the trial, if any, can be detected. And our book hopes to provide impulses to change this as well. Thank you.
Thank you very much, Philipp. We will have an opportunity to delve into more depth the multidisciplinary scholarship that you've already sketched. With contributions indeed from both legal scholars and historians throughout, the three-part anthology deliberately features multiple readings of the trial and combines different perspectives. As series editor, I'm particularly pleased that the book is published in the Nuremberg Academy Series. Indeed, the historical background of the tribunal, its establishment, its functioning, substantive and procedural aspects, as well as the repercussions and receptions of the trial are treated at length in various chapters. The wide-ranging issues are often discussed from varied perspectives, and contributors sometimes draw markedly different conclusions, thus providing insightful accounts. Indeed, both the Nuremberg and the Tokyo Tribunal laid an invaluable foundation for the edifice of modern international criminal law. The Nuremberg principles had been recognized while the Tokyo trial was ongoing, and indeed were officially formulated by the International Law Commission in 1950. Of course, despite important similarities to the Nuremberg Tribunal, the Tokyo Tribunal was distinct in its organization, its functioning, and its jurisdiction, as well as the complexity it faced. And we will get into that in just a moment. Now I invite our panelists to join me for a panel discussion. Kerstin von Lingen, Philipp Osten, Yuma Totani, and Gary Simpson, who is joining us in a short while, I understand. We will touch upon several topics here today: the multidisciplinary scholarship, the appreciation of the Tokyo Tribunal in Japan and internationally, accountability for international crimes, and the wider ongoing significance of the Nuremberg and Tokyo trials then and now. I'm looking forward to the discussion now. So first, let's turn to the wider multidisciplinary scholarship and the state of the art of research on the Tokyo Tribunal. A voluminous literature has been developing and continues to evolve. Questions have arisen regarding the relevance and the precision of previous portrayals of the Tokyo Tribunal, given the dearth of comprehensive research and multidisciplinary research and the related gaps in knowledge and understanding. First, we will speak about the English language scholarship before turning, of course, to the Japanese language scholarship. Professor Yuma Totani, who is joining us from Hawaii today, let me start with you. In your view, what have been the most relevant catalysts that led to the revival of and most significant appraisals of the various layers of the Tokyo legacies in recent scholarship?
I think the answer is quite straightforward: ICTY and ICTR. With the establishment of these tribunals, there was a sudden interest in historical precedents, and naturally one would turn to Nuremberg, and that in turn would lead one to take notice of its Far Eastern counterpart, which is Tokyo. And that in turn will lead one's attention to a much broader range of trials that were held in Europe and the Far East contemporaneously. So if one would like to have an understanding of historical precedents, one would have to start with Nuremberg, Tokyo, and the rest of the Far Eastern tribunals. So, and then think about what kind of present-day relevance these tribunals and their judgments have to the present-day trials, war crimes trials. So that would be my very simple and I hope an apt answer.
Thank you, Yuma. Excellent. I mean, why did it take so long for scholarship on the trial to gain relative prominence in your view?
That's another excellent question. And the answer is quite simple again. Richard Minier, Victor's Justice, published in 1971. It was a highly influential book looking at the historical significance of the Tokyo trial. It did utilize the trial records, but it was written as not so much as a book on the trial per se, but rather as a critique of the US policy on the Vietnam War. So there's an interpretive slant, so to speak, in how the Tokyo trial was treated in this book. But when it got published, there was a lot of positive reactions. So as far as I can gather from the later writings about this book, it was published at the time of the Vietnam War. There are a large number of individuals in the United States and beyond who are critical of the Vietnam War, and they are looking for various tools and means by which to make a powerful criticism of what the United States was doing in the Far East. And there was a sense of general agreement that the American self-righteous foreign policy did not start with the Vietnam War or the Korean War, but it could go all the way back to the US occupation of Japan in the wake of World War II, and more pointedly manifested in the Tokyo trial. I do not agree with this interpretation, but that's the interpretation presented by Professor Minya, and there are a lot of people who took a very sympathetic view of that take. So, and that impact endures to this day.
I mean,
regardless of your publication of your edited volume, which I think is really going to further transform the dynamic of the conversation. Richard Minya's Victor's Justice, for a variety of reasons, and especially for the reason I just stated, continue to have a huge influence.
I mean, thank you, Yuma, for pointing that out. Let's remember that when noting that the Tokyo Tribunal fell into obscurity and there's a relative paucity of scholarship in the early decades since the holding of the trial, it's essential to recall the unavailability of the trial transcripts, as has been mentioned. A significant milestone in this regard is, of course, John Pritchard's publication of the trial transcripts in English in 1981. So I'd invite Kerstin to briefly comment, what's your view there in terms of the availability of sources, historical sources, for the development of historical scholarship on the trial as you see it?
Well, obviously, as you just mentioned, the availability of the transcripts is quite crucial, but for historians, we also need the availability of the diplomatic records. So as normally archives have a different phase of limitation where you can't see documents, this has started at different times. And I would say that in the mid-2000s, we had all equally access to all diplomatic documents, and so we could access the national strategies behind sending a judge to Tokyo, which is a very important point from the historical point of view. But obviously, Yuma's book in 2008 on the Tokyo Tribunal was a milestone for historians. And by reading Yuma's book, we all thought, we should do some research there as well.
Absolutely, absolutely. Following the turn of the millennium, we have seen this resurge in interest and a burgeoning scholarship, especially in English, but also in other languages such as German and Chinese. Indeed, a vibrant research field emanated in Japan already decades ago, so producing prolific and groundbreaking scholarship in Japanese. So I'd ask Philipp to briefly give his take on the vibrant field that emerged in Japan ever since the holding of the Tokyo trial. Yes.
Yes, yeah. Okay. So if you take a look at the developments in the scholarly debate in Japan, it is interesting to note that perhaps the most vivid discussion took place in the immediate post-war area during or shortly after the trial. At least from a legal perspective, in this time, the most interesting, the most stimulating, and the most conceptual debates took place, mainly conducted by eminent Japanese legal scholars at that time. And some legal concepts which are now generally recognized in international criminal law, such as purposes of punishment or other notions, were already anticipated by some of these Japanese scholars in publications reflecting on the Tokyo trial more than 70 years ago. So this is a very interesting debate, but this debate is more or less forgotten nowadays, even in Japan. And one can say that the law which was applied in Japan, in Tokyo, the legal concepts, especially the concept of core international crimes, was never fully accepted in Japan in the following years and decades. To the contrary, one could say that maybe criticism pertaining to the principle of legality and, of course, to victor's justice seems to have had much stronger, maybe decisive influence on the shaping of the debate in Japan. So it remains at least questionable whether the legal legacy of the trial has really taken firm roots in Japanese scholarship. And this is also not only a scholarly question, this is also reflected, for example, by the fact that even after having acceded to the Rome Statute of the International Criminal Court, Japan decided not to incorporate the core international crimes into the domestic legal order. So in essence, my point is, in Japan, we used to have a very interesting legal debate, which is more or less forgotten. And at presently, the trial is mostly the subject of historical and political discussions, but not a legal subject. Thank you.
Thanks very much, Philipp. And I know your chapter is precisely on the crimes in the Charter of the Tokyo Tribunal and their receptions in contemporary Japanese legal scholarship. You highlighted historical scholarship, so I'd like to ask Yuma to jump in here in terms of what is your view on the development of the Japanese language scholarship and the pioneering works that have been written in Japanese?
Well, thank you for an excellent question. So as Philipp just pointed out, there was a group of legal scholars and social scientists right at the time of the Tokyo trial who observed the proceedings and read the judgment in one way or another, maybe read the summary in the newspaper or whatever. And they made an incisive analysis of aspects of the trial. But what they produced did not impact the public debate on the Tokyo trial. And what they did is lost in a broader literature on the Tokyo trial since. But this is not to say that there wasn't any debate on the Tokyo trial, but it was largely politically defined from the 1950s all the way to the present. It's Tokyo trial was, whether the Tokyo trial was a victor's justice or not, this kind of thing is there in the Japanese public discussion throughout the post-war period. So, but when one would like to have a better understanding of the scope of the Japanese language scholarship on the Tokyo trial, is that one do not look at this public debate, but rather look at a new research initiative taken by Professor Awaya Kentaro, who unfortunately died recently. He was a professor at the Rikkyo University. He, from the late 70s, started utilizing those records, diplomatic records that Kerstin mentioned, deposited at the Allied Archives, to have a fresh look at the behind-the-scenes dealings, so to speak, between the Allied authorities and the Japanese authorities in the making of the Tokyo trial. And his findings were really fresh and largely unknown until he recovered those. And there, ever since, he really, what he has done really shaped what the field of the study, the Tokyo trial as a field of study, was to be. So, and that continues to have a huge impact on the Japanese understanding of the trial. Now, there are a couple of things to be said about the research initiative led by him and then expanded on by the generation of scholars who got into this field in Japan. So because of the fact that they take advantage of the declassified diplomatic records, And because these scholars are largely interested in political aspects of the trial rather than legal, their scholarly output necessarily focuses on the political issues of the making of the trial. As to the legal aspect, and that's my second point regarding the nature of the scholarship, is that, so the legal, when it comes to legal issues of the trials, Professor Awaya and those who are inspired by him tend not to write a great deal for the sheer reason that they are not trained in relevant legal studies. So, and that continues to be the case to the present. The studies of the Tokyo trial in Japan were led primarily by historians. Philipp is an exception. And I don't think there are many like him, legal scholars who take an interest in the historical analysis of the Tokyo trial. From that perspective, the volume you have just published is a very important one, and hopefully it gets translated into Japanese, because as you just pointed out, it's got an interdisciplinary dimension, and which includes the legal analysis of the trial, which are still in wanting in Japan.
Well, thanks very much, Jolana, for highlighting the necessity of being thorough in the law and in history and being well-versed, obviously, in the respective fields. You rightly highlighted the very rich scholarship that exists, and of course, our book builds on the vast and terrific research that has come before us. Let us turn to our second topic, which actually neatly ties to this particular topic of how it's been reflected in the scholarship. Let's turn to the wider public for now, and the appreciation of the Tokyo Tribunal in Japan in particular, then and now. Here I'd ask Philipp to kick us off, and how has the Tokyo Tribunal actually been remembered and received in your view?
Well, this maybe also leads us to the question whether, from a Japanese point of view, the trial can be considered to be a Japanese trial also, and not only a trial adjudicating acts committed by Japanese. This is actually one of the most controversial aspects of the trial. And obviously, the view of many Japanese then and now, the trial was conceived to be a mainly American, in any case, a foreign undertaking, one-sidedly directed against Japanese leaders. However, this is also the kind of debate which took place in the wider public. But if you have a look at this issue from a different perspective, one could perhaps argue that the tribunal conducted legal proceedings against members of the Japanese wartime leadership, which could, or maybe even should have been conducted by the Japanese themselves, as the Japanese people at that time considered themselves as also being victims of the destruction brought upon them by the war policy of their leaders. And in this regard, I think that the participation of Japanese in the tribunal, or even war crimes trials run by Japan, could have been an at least theoretical option. And however, maybe practically this probably wouldn't have really worked out, considering the fact that actually a few proceedings were installed against Japanese soldiers for war crimes by Japanese court martials, which were supposed to prevent the Allies from prosecuting war crimes. They really didn't work out and didn't prevent the Allied powers from establishing the Tokyo Tribunal. But in this context, if you take a comparative perspective, when comparing Nuremberg and Tokyo, one striking difference is the fact that after these foreign or internationally conducted tribunals took place, in the case of Germany, German national courts eventually began prosecuting Nazi perpetrators, at first very reluctantly, but they still do so today. And compared to this, it is striking to note that no Japanese national was ever prosecuted for war crimes by a domestic Japanese criminal court. And I think that in this regard, balancing the relationship between international courts and national courts when prosecuting grave international crimes. The international criminal law as a whole has moved on and made progress. International courts, such as the ICC, now generally give prevalence to national courts, according to the principle of complementarity. So this could be maybe also one of the lessons we can deduct from the experiences made in Tokyo. Thank you.
Thanks, Philipp. And allow me to follow up with Yuma, who obviously also intimately knows the debates taking place in Japan. I fondly remember when I was invited to Tokyo for an anniversary event entitled The Present Day Significance of Nuremberg and Tokyo in Modern International Law, which took place on the anniversary of the 70th anniversary of the judgment in Tokyo. Yuma, I know you were a speaker at that conference. What is your sense of the public debates about the Tokyo Tribunal in the present day?
Yes, that's an excellent question. So there was another big conference in 2008 celebrating the 60th anniversary of the judgment of the Tokyo trial. At the time, there was a sense that this was a big deal. 60 years is by the Chinese zodiac or whatever, means that the life comes to full circle. So it's a great time to stop and look back and reassess the whole thing. So the whole year, there was just a huge excitement about the Tokyo trial, even though it was still and continues to be today referred to as victor's justice. So there was a huge public interest. The 70th anniversary in 2018 was a little bit different. There was some degree of interest, and that's why the University of Tokyo at Komaba, which is a one of the top universities in Japan, took the trouble of hosting an event, inviting you from the Nuremberg Academy, Viviane, and Judge Liu from ICTY, and myself and David Cohen to have a conversation on the significance of the tribunal. There was a coverage of this event, and there are a couple of other things going on contemporaneously. But I get the sense that the Japanese public has run out of steam. After the 60th anniversary, they may have felt that they are done with the Tokyo trial in terms of debating and analyzing, trying to have a deeper understanding of it. So I felt that the Tokyo trial may not be all that significant anymore. That said, there are two things going on in Japan, as far as I can see. As I said earlier, at the surface level in the Japanese public, there is a sense that the Tokyo trial was a victor's justice. It doesn't matter what kind of groundbreaking research was done by scholars. It was victor's justice, full stop. And that's the politics of the trial that will, I don't think, ever change, unless there is something that forces the Japanese public or the Japanese government to change the nature of the debate. So that's one. But on the other hand, the Japanese public is very well read. You'll be amazed by the depths of knowledge that an ordinary Japanese would have about the trial, and their readiness to provide very informed, complicated set of questions. I got readers, non-specialists responding to me, double-checking facts and asking questions and things like that. So the reading public has a much deeper and broader and complex understanding of the trial, and they are ready to take the next step so that they can influence the public debate. These are the two things I think, as of the 70th anniversary of the Tokyo judgment, you can sense as occurring in Japan. That's my my impression.
I mean, during my stay then in Tokyo, I had the privilege of visiting the place where the Tokyo trial was actually held and joining a tour of Ishigaya Memorial Hall as part of the premises of the Japanese Ministry of Defense. It was powerful to see the place where the Tokyo trial had taken place. And as you might know, in Nuremberg, there is a exhibition that opened over 10 years ago now, the Memoriam Nuremberg Trial. So I'd be curious, Yuma, if you could just comment briefly on what you see as the current reception of the actual historic venue, the place where the Tokyo trial took place.
Yes, so thank you for that. The Ichigaya Memorial, I haven't visited myself, but by that name, Viviane is referring to the remnants of the former building number 1 of the Japanese Army Academy. That particular building was dismantled and then reconstructed to create what now is referred to as the Ichigaya Memorial. And it preserves the auditorium and some of the rooms of the original building. The original building used to function as part of the Army Academy. And during the Asia-Pacific War, it housed the Army General Staff Office, as well as the Ministry of the Army. And then, as we all know, the building was taken possession of by the Allied authorities right after World War II and was converted to accommodate the International Military Tribunal for the Far East. From the 80s onwards, there are citizens' movements from the cross-section of society to preserve this building. There was a plan to get rid of it with the transfer of the Defense Agency, which is the predecessor of the Ministry of Defense. There was a huge desire to preserve it for layers of historical significance that this building has, which means a great deal not only to the right but also to the left. So these movements converge in such a way that ultimately it was decided that parts of the building will be preserved, and that is now the Ichigaya Memorial. Now, so there is a citizens group that is committed to not only to preserving the memorial, but to persuade the stakeholders to change it further into something that looks like the Nuremberg Academy. I don't think they are yet to think about the kind of educational and research missions that you undertake to be part of the possible future mission of the Ichigaya Memorial, but they do want to have the kind of exhibits, permanent exhibits you have in order to teach to the general public as to the historical significance of this structure. So we'll see. It doesn't look like we are going to have the Tokyo Academy yet, but I think that because of the surge of legal studies of the trial by under the leadership of the Nuremberg Academy and by the contribution of many legal and historical researchers, and because the Japanese people reading public is reading their final products, there may be a new kind of conversation in Japan about the creation of such a place.
Thank you very much, Yuma. Very interesting to continue following the developments. Allow us to broaden the debate in terms of the appreciation of the Tokyo Tribunal. And I'd like to invite Kerstin in to join us in the discussion in the sense of turning to also our third topic, which ties in directly with this, which is, at the moment the Tokyo Tribunal was held, it was an international undertaking. For some, it was a shining moment of multilateralism, if you like. Kerstin, I know you've had a long pedigree of researching the Tokyo Tribunal under the aspect of the transcultural nature of the trial and of the justice dispensed. What is your view in terms of what makes it precisely a transcultural endeavor? What is the nature of the trial, and why does it matter for the appreciation and the accountability that was sought?
Yeah, thank you very much for this excellent question. Maybe to briefly situate my research, I was lucky to receive funding at Heidelberg University to conduct a research group active for about 5 years about research in transcultural justice in the Pacific trials in Asia. So we have looked at the Tokyo Tribunal from different perspectives, but also at the national trials, the so-called BC trials. And maybe as a general finding for the whole group's endeavor, I can underline that we need to pay way more attention to the background of actors involved in judgment. So all these lawyers and judges involved had obviously already been in high positions within their home countries, although most of them had no experience with international law and none of them had ever been to Japan. And I think that the political context, so formed by the old wartime alliances, but also new frictions emanating from the Cold War, was highly complex. And this resulted in the outcome of what we call today justice, whatever that may be. And this is the next question. So it might be that we undervalue still what a perception of justice is for a judge grown up in Europe, for one grown up in North America, or for a judge in Asia. So we might even come in the problem not only of culture, but philosophical, ethical, moral implications. And returning to my point of giving back agency to agents of law, I would really like to briefly name the 11 judges involved. So we have William Webb for Australia, we have Lord William Patrick for the United Kingdom, Edward McDougall for Canada, Erima Harvey Northcroft for New Zealand, we have Mei Ruao for China, Ivan Zarianov for the Soviet Union, Bernard Röhling for the Netherlands, Henri Bernard for Free France, Radhabinot Pal for India, and Delphine Jarania for the Philippines. The US sent first Judge Higgins, and he was later replaced by Myron Kramer. So the fact that 6 of the 11 judges were familiar with Anglo-Saxon law and common law influenced the tribunal quite heavily. So we have different traditions of law visible in this trial. And also the prosecution was organized under US leadership. So as Joseph Keenan headed the international prosecution section, and all national teams sent then in their so-called associate prosecutors. And there was also this mixed defense team. So we have, because of the problem of the Japanese attorneys, as they were neither acquainted with English nor with legal procedure in Anglo-Saxon law, a US team was sent in to support the defense team. This is a unique feature. We didn't have that in Nuremberg, so I find it really interesting as a historian. And obviously, every nation was responsible for a certain period within the trial for some of the charges. So, which was connected to several charges which were of special importance for the country that brought them up. So you can even talk about a kind of narrative of the Pacific War, which has already been on display during the Tokyo Tribunal. And in this area, I'm always speaking in my research of arenas of justice or of trials being platforms where not only law or whatever justice is discussed, but also politics, wartime alliances, and the question of guilt, if we emphasize that in this regard, is more a debate about whether wartime choices had been right or wrong. So this is the interesting point I would like to make as a historian.
Very fascinating, and of course to really dissect this transcultural nature, as you have eloquently done so. Indeed, accountability efforts and international criminal trials are a pervasive feature of peace and justice debates today. Turning to the law in response to crimes has become much more ubiquitous and commonplace. And though not the first to hold individuals responsible, both the Nuremberg and the Tokyo trials represent landmarks, and much of the innovation was, of course, the individual criminal responsibility. And I know, Yuma, you've written your chapter on precisely individual responsibility. Would you like to comment on the importance of individual accountability at the time of the Tokyo trial?
Sure. I
just see that Gary Simpson has joined us, has been able to join us from London. Good to see you, Gary.
Hi, Gary.
We were just discussing the accountability for international crimes and the individual criminal responsibility, and I just had asked Yuma to elaborate on the importance of individual responsibility for crimes, and then I'll bring you in immediately for your take on the interplay of law and politics in just a moment. Over to you, Yuma.
Yeah, I don't think it needs me for us to reach an understanding that the principle of individual responsibility to hold for international crimes is fundamental to international criminal justice today, and since the time of Tokyo and Nuremberg to the present. And we have look at how this principle was applied at Tokyo from different perspectives in the edited volume. The point I would like to underscore, though, for now, is that as we talk about individual responsibility, we are looking at those individuals who held positions of authority in organizations. There, in other words, organizational dimensions in what they did in terms of they used the power and authority vested in them by holding particular offices, and by which they made the occurrence of crimes possible. That's the kinds of accused we are dealing with at Tokyo. And moreover, the kinds of crimes we are looking at in the Tokyo proceedings are quite a few of them have organizational dimensions. For instance, use of POWs for forced labor. The evidence of comfort women was just a little bit was accepted at Tokyo. Again, comfort women, that's another kind of organizational crime committed by multiple individuals, some serving in the government, some in the military. At Tokyo, not a full analysis of those problems were done, but the point is that we are looking at crimes committed in organizational manners by individuals who held positions of authority in different kinds of organizations, government, bureaucracy, the military, private businesses, etc., etc. So I think that the significance of the Tokyo trial is that the judges look at the evidence to have an understanding of what kinds of power and authority were vested in each of these accused, and how they exercise such power and authority to make the occurrence of crimes possible. I do not necessarily agree that the judgment produced by the majority was a good one. There are some problems, but there are some important sets of standards that they provided that was paying attention to. And also with the President Webb's draft judgment, I don't know if we will have time to talk about it, but these are the kinds of things that we should keep in mind as we talk about individual responsibility for international offenses.
Thanks, Yuma, and I hope we will get into the judgment in just a short while. You highlight individual responsibility as a fundament of international criminal law, and of course it's also articulated as the first Nuremberg principle. Gary, let me invite you into our discussion, and I know in previous scholarship you've written about that all trials are political trials, not in the usual blunt sense of the critique that these are political trials, but that actually concepts of the political are perpetually at play. Could you briefly comment on how you see the interplay of law and politics for the Tokyo Tribunal, but also accountability efforts today?
Yeah, well, first of all, I'm delighted to be here, and congratulations on the book. I really look forward to seeing the hard copy. I'm sorry I couldn't join you earlier, but in fact, I've just been in a class teaching two cases, namely one the Milosevic case at the ICTY and the other the Bosnia-Serbia case at the ICJ, and it relates to the previous question, which relates to the question you've just asked me. I think one motif in international criminal law, and it's a motif at the Nuremberg and Tokyo war crimes trials, is the relationship between individual responsibility and either collective responsibility or state responsibility or organizational liability, as Yuma just discussed. And in a way, we've gone back and forth oscillating between these two modes of liability throughout the history of the discipline. I mean, one can tell this story in a historical way, moving from Versailles with its emphasis on collective responsibility, reparations, sanctions, through to Nuremberg and Tokyo, or Tokyo-burg, and the sort of high point of individual responsibility, and then back through the Security Council's imposition of sanctions in places like Serbia and Iraq in the late 20th century, and then onwards to the sort of high points of the ICC and so on. But one could also retell this story as a series of moments in which these two ideas, and they're both political ideas in a way, the idea of holding individuals responsible for high-level crimes in international law and holding whole communities or states or collectivities responsible, have been a constant feature. So, I mean, for example, Versailles is also a moment which involved the contemplation of the trial of the Kaiser for specific charges of war crimes and the crime, or what we now know as the crime of aggression. And Tokyo and Nuremberg have, I mean, more features of collective responsibility than we might imagine. And certainly around the trials at Potsdam, for example, there are clear examples of state responsibility and collective responsibility. Think of the mass movement of peoples, or the redrawing of German borders, or the idea of organizational criminality at Nuremberg and Tokyo. So, I mean, these are political matters. But international criminal law has a slightly strange relationship, or an uneasy relationship, to politics. In a way, it's always trying to escape it. Of course, the idea of an international criminal justice is to be apolitical, and judges, prosecutors, and so on are constantly making that claim, and it's very appropriate that they do make that claim. It's not up to the lawyers who participate in the cases to describe these cases as political. It's up to us as intellectuals observing the cases to think through the politics of international criminal law. But I would say that it is a politics. Judith Sklar, who writes on this matter in the early 1960s in her book Legalism, talks about this issue. She says that the choice of tribunality is a political choice. One could deal with these problems in a number of different ways, through war, through assassination, through truth commission, through reparation, through amnesty, through doing nothing much at all. But at Nuremberg and Tokyo, the international community made the choice of law, or the choice of tribunality, and it itself was a political choice, and it brought a whole series of a whole politics in train with it. It's the politics of legalism, if you like. So I think that's what I would say about. I mean, there's a lot to be said about the relationship between politics and law in these trials, and I've said it at great length elsewhere. But that's the point I'd like to make today, at least, that at the very least, international criminal justice can be seen as a political choice, and is experienced certainly by defendants in Japan and in Germany. It was experienced by the defendants as a political act, as a political decision, or to put it in Judith Sklar's terms, it was the liquidation of political enemies using judicial process. It's a rather grim diagnosis, but at least it's one view of what war crimes trials do and achieve.
Thank you very much, Gary. And on this precise interplay of law and politics, I'd like to bring Philipp back into our discussion. I know you also wanted to briefly comment on the current day appreciation in Tokyo itself.
Sorry, no. Actually, at an earlier stage, I had difficulties in there were some noises and I couldn't understand what your observations were, Viviane, when you were in Tokyo, actually visiting the premises of the building in Ichigai. And I just wanted to make a short footnote. I'm not sure if you may have noticed that one of the most prominent exhibits in the former, in the building, in the memorial building now, where formerly the trial took place and which was rebuilt, as you have heard now, one of the most prominent exhibits is actually the dissenting opinion by Judge Pal. It is actually placed in a location you can't overlook. And this is very telling, I think, about how the memorial is supposed to appeal to visitors. This is just but a short footnote, and let me allow maybe to briefly comment on just one aspect which Kerstin just raised with regard to transcultural endeavors and the influence of different legal cultures on the trial and on the reception of the trial. And this is also, of course, important for the perception of the trial in Japan. And one aspect which is often overseen is the fact that not in substantive law, but in procedural law, the Tokyo proceedings at the Tokyo trial did have a very strong impact and influence on the Japanese legal order. I previously said that the law applied in Tokyo was not accepted in Japan so far. This applies, of course, to the core crimes, but with regards to procedural criminal procedural law, it is interesting to note that the IMTFE was the first trial conducted in Japan based on an Anglo-American adversary model. And this was very, very new and was a novel model for Japanese scholars. And this strongly influenced the Japanese Criminal Procedure Order Act, which was enacted shortly afterwards. Some of the scholars and practitioners who drafted the new Japanese Criminal Procedure Act were strongly influenced by this model, by what they saw in Tokyo in the courtroom of the IMTFE. So there is this very strong but very often overseen impact of the Tokyo trial with regards to criminal procedural law. Japan was until then modeled on continental European models of criminal proceedings. So this is just these are just two short footnotes. And based on what Gary just pointed out, and also what Yuma discussed earlier, I would just like to add that in the present debate in Japan on the Tokyo trial, the question is often discussed whether the tribunal can be regarded as a negative example in international criminal law, considering the criticism pertaining to historical selectivity, victor's justice, and all the other criticism we have already heard about. But this was actually not only voiced in Nuremberg and Tokyo, but as we know, it was also revoked in the case of the two ad hoc tribunals, and it is actually also being revoked with regards to the ICC recently, and it continues to be a challenge for international criminal law. So one could really ask, was Tokyo a negative example? This is actually at least something, or did it have a negative precedential effect? This is a question which, in my eyes, seems to be a little bit underexplored so far, and I hope that future scholarship will be able to take upon this question as well. One might argue, of course, that one-sided or selective justice, selective prosecution of war criminals is still better than no prosecution at all. But I think these are fundamental or structural problems which we still have not fully overcome in international criminal justice so far.
Thanks, Philipp. And we're actually squarely in the final topic that we're discussing today, namely the ongoing significance of the Tokyo Tribunal and the Nuremberg Tribunals then and now. And I know, Gary, you coined this very interesting term Tokyoberg, which cogently captures the idea of a single event, a transformative moment, if you like, in history of war crimes trials and this conjunction of Nuremberg and Tokyo. Could you briefly elaborate on this concept and the coinage of Tokyoberg?
I can't remember when I coined this phrase, or indeed even if I coined it. There may be somebody out there who would claim to have used it first, but I was trying to capture the idea that this was a revolutionary moment in international diplomacy. It's a moment when we first began to think about individual responsibility as a serious, in fact, very common response to the problem of criminality and mass atrocity in global politics. And it's transformed the language that we use to describe war and peace today as well. So I think we shouldn't underestimate the effects of this Tokyoberg moment. We often fixate on whether Nuremberg and Tokyo led to future developments in international criminal law in the 50s and 60s, or we work out whether it's significant for the current period. And that's all very reasonable. It's important to think about the institutional similarities and parallels between Tokyoberg and the ICTY and the ICC. But I think just as important, maybe more important, is the effect that Nuremberg and Tokyo have had on our thinking about international diplomacy. It's almost inevitable, invariable, one might say, for states now to think in terms of war crimes trials or trials relating to crimes against humanity at the end of wars. So when Prime Minister Blair was the Prime Minister here in Britain, I think the United Kingdom fought 5 wars, and arguably looked at in a certain way, there were 5 sets of war crimes trials after those wars. That's a major shift in national thinking in Britain, and it's a major shift in the way that we collectively around the globe think about matters of international diplomacy. So when I hear people worrying about whether international criminal justice is weak or strong, and normally we worry that it's weak, my response is it's actually been extremely powerful as a device to get us to think differently about the world. But I do, just in response to the previous discussion about Tokyo, I think it's also important, paradoxically, to separate them out a bit. Though they can be understood together, a la Tokyoberg, I think they're very, very distinctive. And I should say that in some ways, Tokyo has been much more influential, or just as influential in the current international criminal justice system as Nuremberg. I mean, as we know, and as Yuma and I have discussed at previous seminars, Tokyo was a bit of a forgotten sibling, at least in the West, for a long, long time. I mean, there were people in my classes who didn't know there had been a trial at Tokyo. They knew the Nuremberg trial, but they didn't know the Tokyo trial. But Tokyo is a precursor in some respects, at least 2 I can think of, and I'll finish there. One is in the sense that it was established by decree by General MacArthur. It resembles the ICTY, the ICTR, and all the various hybrid tribunals. So most tribunals are established by a very overt political decision, sometimes by the Security Council, sometimes through other methods, rather than through treaty, a la the ICC. So in this regard, Tokyo, with its sort of discretionary constitution, is the precursor rather than Nuremberg. And then in a second, I think even more important respect, if I just put it, if I could say sort of multicultural, or I think you used the term intracultural in the preparatory documents for our discussion, and you've already discussed this point. In its intracultural elements, it resembles more the contemporary scene than Nuremberg does. The assortment of judges from different regions of the world, Justice Powell, Justice Rowling, and so on and so forth, resemble the sorts of panels of judges we have now in international criminal justice, whereas Nuremberg, with its 4 or 8 white men presiding over the world, seems to be, a sort of slightly archaic or antique form of international criminal justice.
Thanks very much, Gary, for that. And in fact, I'd like to thank all the participants who have been submitting questions. We've received a number of questions already, so I'd like to fold in the questions now as we continue our discussion on the significance. And one question ties up precisely to the conjunction or the juxtaposition of Tokyo and Nuremberg. And I'd like to address this to Philipp, as the participant did. The IMT and the IMTFE are often referred to as twin tribunals or sister institutions, as Gary just called them. And it's interesting to consider how these two tribunals' similarities and differences affected their results. Philipp, could you comment on precisely the similarities and the differences of the tribunals and how it affected their results? Thank you. Philipp, if you unmute yourself, that would be great.
Hello, can you hear me now? Sorry. Yeah, this is a very good question, which also brings us to the core of many legal issues underlying the tribunals. But if I would have to answer it fully, I think this would go beyond the time frame we have today. So maybe just 2 or 3 very short points. One already mentioned by Gary is the different legal foundation, an order more or less, or a declaration on the one hand in the case of Tokyo, whereas in the case of Nuremberg we have a kind of an international treaty. Of course, Germany was not part of this treaty, as with the charter attached. So we have these technical differences, but I think the question. Sorry, the question was what are the main differences in a legal context? Is that correct?
So how the main differences then affect the outcomes of the Tokyo and Nuremberg?
Well, I guess it is obviously easier to generate consensus between 4 judges than all coming from rather similar legal cultural backgrounds than between 11 different judges, and the fact that in Tokyo 11 judges participated, of course, also contributed to the length of the trial, and of course one should also keep in mind the language problem, which is another issue which is mentioned, which is also taken up in our book. One chapter of our book is actually dedicated to language and the translation and interpretation problems of which occurred in Tokyo. The Japanese language turned out to be a far more difficult language to deal with in court at that time, and this also contributed to the fact that the Tokyo Tribunal took more than twice than the one which took place in Nuremberg. And if you have a little bit, if you look at some more legal details, for example, the interpretation of the concept of conspiracy, which was applied in Nuremberg and in Tokyo, is slightly different, and other such details can also be detected, for example, with regards to the concept of command responsibility, as it was treated differently in Tokyo and in Nuremberg. But I think this goes beyond the scope of our webinar today to deal with all details. Yes, these the structural differences had a lot of effect on the outcome of the trial and also on the proceedings themselves.
Thanks, Philipp. And you just mentioned the proceedings. We've received a couple of questions actually on the dissents that were integral part of the Tokyo trial. And I'd like to there say and just read out the questions. It seems that the dissents garnered significant sympathy in Japan and interest in post-colonial discourse, particularly with regard to Judge Pal's dissent. I'd like to bring in Kerstin here in terms of the historical appreciation, how the majority judgment, but also the separate and dissents actually were taken up, and how you see that has affected the appreciation of the Tokyo Tribunal.
Yeah, thank you. This is an excellent question. I was also still to make my point that we always have to be in mind that the Tokyo Tribunal did not happen in an empty space. But the aftermath of the Second World War in Asia is a battle of decolonization. And in a way, the Pacific War has also been fought by Western countries to regain their colonial possessions. And that was over after 45, and they deeply resented it. So what Judge Pal took up in his dissentment is also the argument that the Japanese army had freed Asia for the Asian people, which is obviously not discussing all the cruelties and atrocities that happened during this conquest and were also to the negative to Asian peoples. But he's making the political point, and this had enormous resonance in Asia and I think even in Japan until today. So the decolonization aspect of the Pacific War is a bit symbolized by this dissent of Judge Pal, and by the same token then obscuring the other parts he's making. So for example, Pal is relying very much on natural law, and he's in a way rejecting the foundation of the whole charter, which is obviously a bit problematic if you are subscribing of being one of the 11 judges and then you reject the tribunal altogether in a way. So, but this is more the legal aspect of it. But from a historical point of view, I'd say that the decolonization aspect of war crime trials, of post-war crime trial in Asia has been really, really important.
Mm. I'd like to actually also invite Yuma to comment, and I'll put one other question that was sent by participant to address to Yuma, which is actually on the recent book that Yuma and David Cohen have brought out, and it's precisely about the majority judgment. So let me just read it for you. The majority judgment did not properly or rigorously analyze the evidence against each individual defendant. In fact, very little percentage of the judgment did so. This is compared to the President Webb's unpublished judgment, which we are still analyzing. But why has it taken so long for legal scholars or historians to make this observation about the majority judgment and the rigorous analysis of actually the evidence against individual accused? Yuma.
That's a great question, and I don't have an answer. And now that there are so many legal scholars interested in the Tokyo trial, we may have more scholars looking into this conundrum and give us a satisfactory answer.
Would you like to comment on Justice Pal and the appreciation that...
Yes, so he wanted to give a judgment on a trial that was imaginary, a trial where the imperial powers, Western imperial powers would be on trial and not the Japanese leaders of the Japanese empire. So in order to create that scene and to make a final verdict of guilty to the Western imperial powers, he makes all sorts of arguments, much of which are largely contradictory. So just to give two examples. On the one hand, he said international law could not apply because it's just a tool of the haves and against the have-nots. So he would reject that. But at the same time, he says he's going to use international law to indict the Western imperial powers. So this is a simple logical contradiction. Another example is that he says acts of state doctrine should apply to the Japanese accused, and therefore none of these 25 accused should be found guilty. And at the same time, he says, but the Allied powers who committed all sorts of atrocity in the past and created this regime called international law, they must be put on trial and must be found guilty. And to them, the acts of state doctrine does not apply. This is another simple example of illogical argument. And this kind of things is there through and through from the beginning to the end. So if you have a logical mind, and if you have a love of reason argument, you are going to have a lot of difficulty reading the Pal's dissenting opinion.
Thanks very much, Yuma. Another question that has reached us is on again, this interplay of law and politics. The question reads, the enduring rebuke to the Tokyo Tribunal is hypocrisy. Many of the acts, though not of all of them, of course, for which Japanese were prosecuted, were also committed with impunity by European powers, the US and China in their own colonies. The ICC is now subject to the same rebuke, and the US has imposed sanctions most recently on the ICC prosecutor. Do you think that international criminal law will ever escape that rebuke? And I'll ask Gary for some initial thoughts on this question.
Yes, very good question. I think the analysis and diagnosis seems right to most of us who observe international criminal justice. It's not exactly that there haven't been people within the field who've tried to perform a form of universal justice and have slightly resisted the attempts of the great powers to sort of utilize international criminal law for particular reasons. And Justice Powell, it's a messy opinion. I agree with that. 900 pages long. It's almost unreadably messy, and then it gets published in an even longer version in India. But there are moments in international criminal justice where you get what I call discordant notes or dissenting judgments. I don't mean just literally dissenting judgments like Rowling and Powell, but moments in trials where you hear a counter narrative. So one of the virtues of international criminal trials is precisely their adversarial nature. It's rare in global politics to hear both sides of the story, to put it bluntly. And yet, if you read the transcripts of international criminal trials, that's exactly what happens. So one could, I mean, this is a more upbeat analysis, I must say, than the question. And I do, as I say, accept the general diagnosis. Whether it can ever be escaped, well, given the structure of the international diplomatic system at the moment, it seems highly unlikely. This is something that, in fact, Georg Schwarzenberger predicted in a marvelous essay in 1950, which sort of anticipated the later critique of international criminal law. He wrote in Current Legal Problems about the problem of international criminal justice, and he said the problem was that we were trying to impose a sophisticated form of criminal justice inherited and migrated from, say, the Anglo-American system to a society which just wasn't ready for it. It was a deeply unequal, inegalitarian society in which certain powerful actors were able to immunize themselves from prosecution and trial. And I don't think that's changed very much, but I'll end this comment again on a slightly more upbeat note. There is a law of unintended consequences going on in international criminal justice. You can't quite predict how things will turn out. You can't quite predict how the norms will be used. And they have been used in a multiplicity of ways, sometimes to resist hegemonic, Western or whatever other sort of power you disagree with in the international system. International criminal justice contains norms, aspirational norms sometimes, but contains norms that are usable and deployable by groups trying to change the world for the better. And so I think we can invest at least some hope in it.
Thank you, Gary. I mean, final question to you. Your opening reflections provide an introduction to the study of the Tokyo trial with an emphasis on reorienting the field and illuminating some of the hidden histories, the unrecognized or perhaps marginalized actors, and the obscured aspects of the trial. What contribution do you see does the edited volume make in this regard?
Well, the thing I really loved about the book are two things. One is it forced me to revise my views on certain standard orthodoxies about the Tokyo war crimes trials. So to give one example of that, William Webb, the Australian judge who presided over the court, has always been understood as this slightly bumbling character who managed to be both sort of imperious and incompetent at the same time. We've got a completely different Webb here in this volume, thanks to at least two essays, the Narelle Morris essay and the David Cohen essay. So Webb comes across as a very, very different individual, actually an individual who'd be more familiar to Australians who held him in much higher regard than international criminal lawyers do. So we've been reintroduced to some familiar aspects of the trial, or those aspects have been defamiliarized. And then secondly, I just been introduced to aspects of the trial I hadn't even thought about. So this is a great molecular, a granular achievement, one might say. The translation issues at the trial, the involvement of women in the trial that's been obscured for decades. So I think it's a great achievement in at least those two respects, but many others besides.
Thanks very much, Gary. Actually, on that note, we are coming to the end of this really fascinating exchange, and I now invite our experts to share some final reflections and comments for a brief moment. And the final question to you is also from one of the participants: what do you see if you were to select one lesson for modern times? Which contribution or significance of the Tokyo Tribunal would you pick? Let's start with Kerstin.
Thank you. Well, I would say that we should have this transitional moment more emphasized. So a trial is coming to terms with the past and guiding into the future. And if we see it, as I proposed, as a transcultural endeavor, then we also see judges coming to Japan who've never been there before. And from wartime foes, you have finally a kind of at least cultural understanding of the other, which is very interesting. And we also see the development of epistemic communities of law, which I find very interesting, and which contradict the historical facts of the time. For example, we know that, for example, Justice Zaryanov, the Soviet judge, was always invited at dinner parties and got along very well with his colleagues. And we are in a high tide of Cold War. And politicians would not speak to each other, but on a let's say, professional level, it was possible to exchange views and maybe even to become friends, not only amongst the international judges, but also with Japanese scholars. And I find that a very comforting, let's say, sign for all the trials still to come, even if we discuss flaws and if we know that there will never be full justice for all crimes that have ever happened.
Thanks. Philipp.
From a legal point of view, as initially mentioned, the most important and significant contribution of the trial is the confirmation of the law of Nuremberg and its further development. The trial has and is still being criticized for having in its judgment, in its majority judgment, simply adhered to the Nuremberg judgment, but this is can also be seen as a confirmation of the law of Nuremberg, and I think it has contributed to the further development of international criminal law. At the same time, such kind of criminal proceedings also serve the purpose of recognizing historical facts, and also in this regard, I think the Tokyo Tribunal has has at least made some contributions. That's all from my side. Thank you.
Thank you. Over to you, Yuma.
The lesson I've taken from the Tokyo trial is to read the judgments and analyze the trial record, without which you really can't understand what the Tokyo trial is about. That's all.
Thank you very much for that concise piece or lesson. Thanks. And finally to Gary.
Well, in a way, I agree with Yuma. Just read the decision and read the dissenting judgments in particular. I guess one lesson I would take is or one great thing that's come out of the Tokyo War Crimes trial is the sense that there is sometimes room in trials for forms of dissent from the existing international order, and the trial has produced a growing and really fascinating body of scholarship, which is an achievement of the trial and an achievement of everyone who's contributed to that body of scholarship.
Thank you very much. I think we've covered quite a bit of ground, and that concludes our event today. Thank you very much to Gary, to Philipp, to Yuma, to Kerstin, and to Jolana from myself. And once again, special thanks to all the contributors, the authors assembled in the book who contribute to this fuller appreciation of the Tokyo Tribunal. The book aims to contribute to ongoing reflections and evolving understandings of the Tokyo Tribunal. And really, it's an invitation to continue exploring fruitful avenues of further research, scholarship, and the perspectives of law, history, and memory. Thank you to everyone who has been with us and has been watching. It has been a great conversation. Thank you very much.